Hello, Ministry of Digital Affairs, who is responsible.
Dzień dobry, reprezentuję Ministerstwo Cyfryzacji. Organizatorzy
Speak Polish, but I will do what is my best to speak slowly and to be correctly understood by everyone who don't speak Polish, who do not speak Polish. Szanowni Państwo, ta nasza prezentacja.
Ladies and gentlemen, my presentation is very simple, but for starters, are there any teachers here? People dealing with education? Teachers only. What is it that GDPR changed in education? What is it that GDPR changed in the first place in this area? Well, it's changed this area very little. And if anything, it's liberalized this area. I started dealing with GDPR in education 6 months ago during the Congress in Łódź titled Education of the Future. This is the place where teachers and other educators meet up. And the most frequent questions asked there was, do we really have to have parental consent after the 25th of May if we want to put the pictures of kids on our website? That was the most frequently asked question. GDPR liberalized the consent requirements. If a parent sits next to a child during any meeting or a conference and is not protesting when they see that the pictures are being taken, it means that they agree for it. GDPR only changed one thing, and Polish education. For those of you who are not Polish among us, I don't know whether you came across such a wave of misunderstanding of this regulation. I think in Poland, GDPR became an element of subculture or culture. If I tell anything about GDPR to a cab driver, he starts showing me memes and making jokes about it. And when I travel in Europe, I cannot see any other country where this regulation changed the privacy protection in such a way it did in Poland. If you enter a hotel in Warsaw or in any other town, even small, you always see a leaflet with GDPR requirements. So this is GDPR in Poland, and this is what we are fighting in the Ministry of Digital Affairs, GDPR absurdities. For those of you who do not understand Polish, these are press headlines. And to say more, these are just headlines, very recent, the most recent headlines, showing how huge misunderstanding of GDPR is in Poland. It says GDPR in school. Student number 5, please confirm receiving your test back. Anonymous tests in schools because of GDPR. GDPR and school, children won't get any awards in the main hall. Turmoil with GDPR in schools. Is monitoring legal or not? Head teachers panic about GDPR. Even nativity plays are in danger. I can tell you, this is all rubbish. GDPR is not going to regulate anything from these, and it's not going to change a thing in this area, with one exception, though, which is using personal data in the web. If a child buys something on the internet, and they can do it on their own, like buying books, manuals, or using email, then the data are specially protected But is it so in every single case? Which leads us to yet another absurdity. Because Article 8 of GDPR provides that processing personal data of a child in the information society services is possible upon parental consent. And indeed, it is so. But GDPR also states that it only pertains to cases where privacy data of a child are collected based on the prior consent. And what happens if a child makes a contract, like, for instance, sets up an account in a gaming service or on Facebook, or buys a book on the internet? Then they make a contract, either with Facebook or with the internet store or with the email operator when they set up an account. They can do it all by themselves because according to the Polish Civil Code, persons who are older than 13 can do that. And in the case of in the case of day-to-day business, they don't even have to be 13 to do it. So this provision only pertains to two situations: newsletter and email marketing. If an internet store wants to use an email of a child communicated by them because they were buying a pair of shorts, if they want to send them marketing communication, they'll need the consent of a parent or a legal guardian. And this is about the only thing GDPR changed in the education sector, apart from social sensitivity, of course. So we can make it very clear, and we can personally turn to a student in the main hall if we want to give them a diploma of recognition, for instance. A teacher can use a number of a student turning to them, but not because of GDPR. Well, I remember it from my primary school that I was called by number. But it was just for me to understand and remember that I was number 9, not because they wanted to protect my privacy at that stage. Because there's no such thing as anonymity in class when it comes to your name and surname. Also, during PTAs, even today, earlier today, one of my employees told me about yesterday's PTA. It was organized in such a way that, they couldn't check the attendance list in the room, and then every parent had to enter the room separately and sign the attendance list. Although teachers and parents know each other's names and they know the names of kids. I could name many such absurdities. So it's a myth. But there's one more thing about GDPR and schools. It says that all legal content dedicated to kids has to be adjusted to the kids. If we have persons older than 13, in many cases capable of expressing the consent for using their image in school, the document they are supposed to sign mustn't be written in a legal, complicated language. It must be written in a simple and understandable language. Kids turn to us at the ministry with questions pertaining to protecting their privacy. And this is a sample reply we gave. Kamil, you need to know that since you sent us correspondence with your name and address, your privacy data were processed by the Minister of Digital Affairs. So then the Minister of Digital Affairs became the administrator of your data. And well, then the kid just needs to check what an administrator of privacy data is. But other than that, it's fully understandable. And also, every public school in Poland, since in Poland the majority of schools are public, is obliged to have a data protection inspector. This is the person you turn to, and this is the person in charge of education and elimination of GDPR-related absurdities. If you have such situations that I described in your schools, it means that something's wrong with the data protection inspector, because they are supposed to prevent such absurdities. Well, so much for my part. If you have questions, I'm your person. I'll stay with you for some more minutes after the end of my presentation. Yes, but please use the microphone, because the interpreters in the booth cannot see and cannot hear the question if it's not asked to the microphone. I'm sorry, I cannot hear the speaker.
Nie ma, proszę państwa,
No. There are no two ways of doing it. GDPR, to this end, is very liberal. Any legal form of affiliation between the DPI and the school is possible. It can just as well be outsourcing an employment contract, but you have to be cautious about the conflict of interest. The legal form is not an obstacle. But you mentioned a very important thing. We tend to treat data protection inspectors as, well, sorry to use this notion, as holy cows. But they are not holy cows. They report to the head teachers, and they are supposed to follow their orders, because the responsibility burden is not on the DPI, but on the head teacher when it comes to data protection. Only the conflict of interest is a major obstacle here. So we mustn't lead to a situation where we evaluate ourselves. If we have the decision-making power when it comes to data protection, and at the same time we are a DPI. It is not possible. So a DPI mustn't be a head teacher, but it can be a teacher. Any teacher with some knowledge on the subject, like, for instance, a history teacher who wants to be a DPI. I cannot see any obstacle here. Yes? Can there be a paradox, like the DPI, a teacher appointed by a head teacher, will monitor him or herself, because after all, every teacher processes personal data. All right. Well, yes, if every teacher processes personal data, there could be a conflict of interest. So maybe my example I gave of a teacher was not perfect. But the only thing you have to mind is the conflict of interest. Any other situation is of no importance. Well, in my subject curriculum, I've got teaching kids how to set up an email account. Do I need parental consent for every kid? To my mind, you don't, because the basis for your work is decided upon by the Minister of Education. Speaking of the conflict of interest, can an HR person at school be a DPI? Well, it's quite simple because, we've got the European Data Protection Council giving guidelines pertaining to data protection. And they mentioned an example of an HR manager in a public institution as a DPI. But I think this is an analogous situation where we've got a chief accountant or an HR officer who would have to evaluate herself or himself. And to my mind, it's not possible then. Well, it's up to you whether we still have time. Okay, maybe the last question. I'm from a Center of Excellence for Teachers. Teachers ask teaching consultants whether it's legal that when we attend teachers' workshops and then the certificate of attendance has to contain name, address, and date of birth, and then the teacher always knows this data. Well, GDPR never changed anything in this situation. So you have to decide whether the data revealed in such a situation is known to participants of workshops. If this is the case, it's like the attendance list of parents at the PTA. It can circulate. But if there is, for instance, a personal identity number included, and participants don't need to know each other's personal identity numbers, it would be good to show due diligence and ask all people to come separately. Just, for instance, to see whether people are not taking pictures of the list. So I've been following GDPR-related absurdity in Poland for 2 years already, and I've seen a lot. But here, in this situation, I would be a bit stricter. It's like during election. A support list can be there, and you can sign it, but it has to be supervised by an authorized person. I cannot see any further questions. Oh, there is one more. Teachers have questions related to electronic note sheet, and they ask about the parental consent. Well, we have to check the attendance list, and then no, it's enough to have a contract, a data processing contract between the school and the operator of the note sheet. No, let's separate two things. Libros, the electronic note sheet, which is based on the regulation pertaining to the attendance lists, also in electronic form. Another thing, however, is the possibility for the school to use Libro's platform, and it requires the contract with the operator. But to my mind, schools made such contracts. But please remember that after the 25th of May, GDPR changed the content of such contracts. So if you never signed annexes to these contracts, and if you're still using the service, you need to sign the annexes for data protection modes, for instance. Although some of the contracts were fully compliant with GDPR even before the 25th of May. This is the role of the DPI at school, by the way, too. Thank you very much.